one legacy issue that many folks have probably heard about, which has just recently raised its head again, is the question of what rate applies to ISP-bound traffic. And 9-10 years ago, when dial-up was the primary means of access to the internet, there was quite a bit of ISP-bound traffic directed to the telecom networks. Litigation ensued in 1999. The FCC issued an order in which it thought it had dealt with that question. The 1999 decision was litigated to the Federal Appeals Court in Washington. Federal Appeals Court told the FCC to try again. In 2001, they determined that an interim rate of 0007 per minute should apply to all terminating ISP-bound traffic. And they said this was an interim decision, that they intended to move towards a full bill and keep regime in the very near future. That never happened. 1 year later, the Federal Appeals Court in Washington reversed the decision, although they didn't vacate it. But they raised questions about the logic, the rationale that the FCC used to determine this so-called interim rate.
Their logic suggested the rate should be higher or lower?
I'm sorry?
Did the court's logic suggest that the rate should be higher than 0007 or some other reason?
The court suggested that they expected the FCC could find a rationale for moving to bill and keep with respect to ISP-bound traffic. Their particular concern was how the FCC interpreted one sub-provision of Section 251, which is the local competition provisions of the Act. So it was a rather arcane legal question about 251G. But at the end of its opinion, it said, we're going to give this back to the FCC because we expect they'll be able to come up with some other rationale to get them to where they want to be with respect to ISP-bound traffic, and that's a bill and keep regime. Despite the federal court's optimism, we're 6 years after the fact and there's no final decision from the FCC. And in those intervening years, several carriers had sued and taken the FCC back to the federal court and asked the federal court to force the commission to rule finally on this question. There were some oral arguments this spring in May before the Federal Appeals Court, and during those oral arguments, the FCC's lawyers told the judges on this panel that they shouldn't act, that they shouldn't force the FCC to finally issue a decision with respect to ISP-bound traffic, because Chairman Martin expected a decision within the next 6 months on some form of intercarrier compensation reform. It's been 7 years at least, right? How long is an interim rate interim? But the fact that the FCC's appellate lawyer told the federal court, the D.C. Circuit, which is the primary federal court that oversees much of the FCC's rulings, was significant. He told them, don't do anything because we're going to act in 6 months. And if you're going to tell a federal court that that's what you intend to do, certainly suggests that they may in fact be doing something. Your question about the status of the Missoula plan raises one other interesting development, and that is recent reports among folks in Washington, D.C. that a new coalition of carriers may offer a new reform proposal. And as you can see, these are some of the largest carriers in the industry: AT&T, Level 3 Global Crossing, and Verizon. We don't have anything on paper yet, so nothing may come of this, but we've heard that what they might do is offer a comprehensive intercarrier compensation proposal. And in it, they would suggest that the FCC could assert jurisdiction, at least for compensation purposes, over all VoIP traffic. And one element of this proposal is apparently the concept of a single unified rate for all traffic, whether VoIP, voice, whatever. Putting aside and pushing aside all of the arcane jurisdictional distinctions associated with local, toll, interstate, international traffic. The timing was interesting, again, because it came just after the FCC lawyers' announcement to the Federal Appeals Court that Chairman Martin intended to do something within 6 months. Whether or not there's any correlation between those two events, I can't say. So, with those different issues in mind, the question is, what are the implications for voice peering? And I think the first question is, do the current federal regulatory compensation rules and regime apply to voice peering? As most folks know, the FCC has, over the course of the last 3 or 4 years, initiated a series of proceedings in which they've systematically begun to impose what most people call social regulation on interconnected VoIP providers. They began with 911. They moved on to universal service. There's a number of other obligations currently required of interconnected VoIP providers. But who is an interconnected VoIP provider? That's the first question. And there's really 4 key elements under the FCC's definition. Enabling real-time two-way voice requires a broadband connection, requires IP-compatible CPE, and permits users to send and receive calls to the public switch network. As I said, those entities, those voice providers that meet all 4 elements would be classified as interconnected VoIP and are currently subject to these 6 different types of obligations. Most recently, number porting and voice relay service obligations have been imposed within the last 6 months. Again, note that Universal Service Fund contributions are required of interconnected VoIP providers, but they don't have any subsidy rights under the program at this time. And although they are required to contribute to the Universal Service Fund, they are not directly subject to access charges and reciprocal compensation at this time. Although they may be indirectly contributing to access or recip-comp arrangements when they are partnered with CLECs who have interconnection to the PSTN. So, with respect to whether or not these regulations apply to your company or your clients, probably the key question, the hallmark, is whether or not there's interconnection to the public switch network. The other 3 elements are pretty common, and so the question almost always comes back to, is there interconnection to the public switch network? Generally, the FCC has defined that as the ability to send and receive calls to and from the PSTN. If there's no connection to the PSTN, you're not subject to the FCC's jurisdiction. If there's some PSTN interconnection, sending or receiving calls to the PSTN, you're probably not subject to the FCC's jurisdiction in that instance as well. One example of no PSTN interconnection is the Pulver Free World dial-up service that the FCC commented upon in 2004. They found that to be a pure information service not subject to the FCC's regulations. Most folks know that Skype now has a pretty successful VoIP service, and they have differentiated their service such that you can purchase Skype in or Skype out. And they've apparently distinguished those 2 services and offered them as separate components in order to avoid the question of direct PSTN interconnection. In other words, you can take Skype in or you can take Skype out, and one or the other allows you to get to or from the PSTN. But unless you buy both services, you don't have that core functionality that allows you to do both. And for that reason, you probably don't fall under the FCC's jurisdiction with respect to PSTN interconnection.
On that subject, if you buy one of those Skype phones and just plugs into your
your internet bridge for your router, you buy only Skype out, are you, because you don't buy Skype in, are you still kind of skirting the rules a little bit?
Are you skirting the rules, or is?
Skype.
Yeah, probably not, because the test is interconnection.